Hello, well, I want to talk to you today about another case that relates to director conduct as we approach or think about insolvency. In other words, how directors interface with the insolvency laws. And the case I want to talk to you today about is Reproduce Marketing Consortium Limited number 2 brackets. Then the citation is 1989 square brackets BCLC at page 520. So reproduce marketing. Why is it important for our subject, and in particular, why is it important for directors? Well, it's a very important case that demonstrates how section 214 of the Insolvency Act 1986 can be applied, and that's of course the section that deals with wrongful trading. So the facts of reproduce marketing tell us what might be construed to be wrongful trading as viewed objectively and subjectively by the court, and of course actually by directors in the way in which they conduct themselves. Why is 214 generally important? Well, as Professor Millman has pointed out, the period immediately prior to insolvency is defined by section 123 of the Insolvency Act 1986 is known as the twilight zone, that period leading up to insolvent liquidation. So as we progress towards insolvency, we know that we're in the twilight zone, the twilight of the company's life. And that in that period, section 214 of the Insolvency Act would operate so as to determine whether or not the directors should continue to trade in that period up to the test for insolvency. Well, let's have a look at reproduce marketing then and its facts to see how that case helps us think about 214. But before we do that, I'll say one more thing about the statutory tests in 214, and that's of course this, that we all should know, or do now know, that section 214 was essentially copied by the legislature for the provisions that would regulate directors not just in the twilight zone as defined by Professor Millman, but also further back in time, right back to liquidity, which is perhaps the wall behind me. Cakes and Ale, Hutton West Cork Railway, good times back there. Directors' duties now, with section 214 extended or recycled into section 174 of the Companies Act 2006, have of course the same test. That's to say, a part objective, part subjective test to determine whether or not some form of behaviour was appropriate. So that's interesting, because of course what it means is that the insolvency laws from 1986 onwards have taught the company's laws something. And yes, of course, that was through the cases of Ree de Jan of London and Norman and Theodore Goddard, 2 judgments of who became Lord Hoffman, then just Mr. Justice Hoffman, extended through the Law Commission and then the CLRSG into section 174, of course. But that discussion is for another time, indeed another module, a company law module. Here we'll stick instead to section 214 and how that operates in an insolvency twilight zone area by reference to reproduce marketing. So here are the facts. You have a fruit company that imports fruit business activities, particularly fruit, as part of its objects. And that fruit company, of course, is really close to the margins of having to make decisions about whether or not it should import more fruit, and if it's sufficiently liquid to be able to do that, to then trade, buy and sell that fruit on. Well, the problem for the directors in this instance is that as well as guaranteeing the company's liabilities personally, in the sense of a potential breach of limited liability, so these individuals had personally guaranteed that juristic person's exposures. The other major problem for them was that they had failed over a period of time, up to 3 years, to obtain proper accounts for the company. And the reason why this is a problem is, of course, how can you determine whether or not your company is technically insolvent pursuant to Section 123 of the Insolvency Act, either on a balance sheet or a cash flow basis, if you don't have any accounts? How do you know? Of course, you don't know properly. And is that behaviour, therefore, which is appropriate? Well, as the facts transpire, it happened to be the case that the company was insolvent and had been for a period of about 3 years, when eventually the directors get some accounts. And as a consequence, the liquidator had sought, or did seek, an order that the 2 directors of the company should be liable under Section 214 to contribute, in his view, just over £100,000 to the assets of the company. Well, it goes to the Chancery Division, where, of course, it was held that those directors were in breach of Section 214 and that they hadn't or couldn't be judged by the standards of reasonably competent directors to have fulfilled their functions, and that they had failed to show a reasonable, diligent approach in exercising those functions. So that, where they should have at least at the minimum obtained company accounts, where they failed to do that, they couldn't accurately say what the financial position of the company was. So they had breached, and they were asked by the court to contribute £75,000 to the assets of the company. So we know then, therefore, that this is a breach of the principle of limited liability, because those directors were asking to contribute, or being asked to contribute, value, not in a capacity as a shareholder, but as somebody who'd breached 214. So it's an interesting case from that perspective. If you want to look at some secondary sources, recently Richard Williams in the MLR has looked at 214 and he's critiqued it, particularly its lack of operation due to a lack of funding. Of course, the assets, Section 436 assets, have to be used to litigate, to bring these actions, causing the office holder to perhaps be nervous about whether or not they would bring such a claim to augment the available estate, to boost those assets. So look at his article, that's one of the most recent ones, of course, Richard Williams, Dr. Williams, in the MLR in 2005. Or for some older scholarship by older scholars, you could look at Professor Key's excellent book, our friend over at Leeds. And he's written, of course, he's prolific, is Professor Key, and here's one example. It's chapter 7 where he examines wrongful trading, and you can look at what he has to say there, or in any of his other outputs, Macpherson, amongst many others. Or you can look at the latest edition, the 5th edition of Professor Fletcher's work, to see what he says about Section 214. Until our next video, then, I will bid you goodbye. So goodbye.